Hello everyone, myself Bhumika Sharma. Welcome back to Vidhi Vigyan Forensic Science. In the previous video, we forgot to discuss about elements of sketching. We have covered the topic crime scene sketching. Please watch the previous video if you haven't watched that. So elements of sketching would include its title or caption, a legend for the abbreviations, symbols, numbers or letters used, compass designation should indicate north, the scale used if it is drawn up to the scale, the documentation block with case number, offense type, victim name, location, scene descriptor, date and time when the sketch was begin, and the sketcher's name. Now coming forward to today's topic, so this is part 4 of unit 1 and it would include courts, their types, power and jurisdiction, admissibility of evidence in courts, definition of experts, provision in Cr.P.C 1973, Indian Evidence Act relating to experts and their reports, and court procedure pertaining to expert testimony and witness. There are two types of trials. First is acquisitorial or adversary, and the other is inquisitorial. So, acquisitorial worked on presumption of innocence, that the suspect is innocent. So, the burden of proof is on public prosecutor. He have to prove that the suspect is guilty. Now, in inquisitorial, it is the presumption of guilty, that the suspect is guilty, and the accused is the burden of proof is on accused. He have to prove that he is not guilty or he is innocent. So acquisitorial system is followed in India. Inquisitorial system is followed by various European countries. Now the courts of law, the various types of courts, section 6 to 25 for of Cr.P.C, Criminal Procedure Code, it deals with the constitution of criminal courts. So criminal courts are basically for murder, arson, rape, these crimes, and are further divided into four. Supreme Court, that is described in Article 134 of Indian Constitution. It is the appeal court. It handles high profile cases. Directly, any normal case would not be uh, handled by Supreme Court. Next is the High Court. This is defined in Article 214 of Indian Constitution. It is also an appeal court. Session Court in section 193 of Cr.P.C. It only try cases which have been committed to it by the magistrate. Assistant Session Court, it can pass sentences of imprisonment up to 10 years and unlimited fine. So this is the hierarchy in the decreasing order: Supreme Court, High Court, Session Court, and Assistant Session Court. So, civil court. Now, civil court is for property disputes, etc. Juvenile court, it is described in section 27 of Cr.P.C. It is for the offenders between the age 7 to 18. Appeal courts do not hold trial. Trial cases are only be in non-appellate courts. Example: juvenile, civil, assistant session, and session court. This classification is based on the types of crime uh, for which these courts can hold trial or appeal for further investigations, further judgments. Courts of law based on their power and jurisdiction. So first is in the ascending order. First is Chief Judicial Magistrate Court. Next is District Court. Third is High Court. There are total 25 high courts in India. States that doesn't have a high court are Goa, Arunachal Pradesh, Mizoram, and Nagaland. Newly constituted high courts are Telangana and Andhra Pradesh. The biggest high court is located at Allahabad, and high court is situated in the capital city of a state, except in the state of Uttar Pradesh. Now, at the top, there is Supreme Court. So, the Honorable Supreme Court of India has ruled that it is not necessary to produce photo micrograph in case of ballistics for the matching of marks on evidences and test exhibits in the court of law. This has been ruled in Ramantham versus State of Tamil Nadu, and it's given in Criminal Law Journal, page 1137 of the year 1976. About the various types of magistrates. Magistrates are defined in section 11 to 19 of CRPC. So, Chief Judicial Magistrate can pass a punishment of 7 years imprisonment and unlimited fine. First class judicial magistrate or metropolitan magistrate can pass a punishment of 3 years with 10,000 rupees fine. Second class judicial magistrate can pass a punishment of 1 year imprisonment with and rupees 5,000 fine. The various types of inquest are police inquest, which is in India, coroner's inquest, Australia, procurator officials inquest, Scotland, medical examiner system, USA. And the medical examiner system is the most superior inquest. Now, from crime scene to court, how the whole procedure is done, these are the following steps. Investigation. First is investigation of crime. The next is recognition and discovery of evidences. Third is collection of evidences, then packaging of evidences, transportation of evidence to the lab, maintaining chain of custody, examination of evidences, safe custody of evidences, transporting evidence to the court, exhibiting evidences in court along with their examination or analysis report, then judgment. Whether the evidence is admissible or acceptable in the court of law or is inadmissible, it is governed by various standards such as Fry standard, Federal Rules of Investigation, and Daubert standards. So, a Fry standard states that the technique or procedure adapted for scientific approach or the analysis of the evidence should be generally accepted in that particular field. And Fry ruling states that it was the first to set the standards for admissibility of scientific evidences in the court of law. So Fry standards are the first one. Next is Federal Rules of Investigation. It governs the admissibility of all evidences, including expert testimony. Expert testimony is given by the expert in the particular field. For example, if there is a drug evidence, so forensic chemist would be the one who will give the testimony, and it is Fry 702. FRI 702. On the basis of expert testimony should be the testimony is based upon sufficient facts or data. The testimony is the product of reliable principles and scientific methods. Next is the witness has applied the principle and methods reliably to the facts of the case. Now, Daubert standards. First is whether the technique or theory has been tested. Next is whether the technique or theory has been subjected to peer review and publication. Next is the technique's potential rate of error. Another is existence and maintenance of standards controlling the technique's operation. So every time we do experiment, we take a control and then our sample and then blank. So next is whether the scientific theory or method has attracted widespread acceptance in the scientific community. Now about Miranda warning. So before investigating a suspect or a person in police custody, the investigator should first introduce himself as a law enforcement officer and then explain to the suspect that what is the nature of offense he or she has been investigated for, and then inform the suspect of his wish to question him on matters relating to his offense. Uh, then advise the suspect of his rights. The suspect should know his rights, so the police officer should first explain him his right to remain silent, that if he or she answered the questions, their answers may be used as evidences against them. Next is the right to have legal counsel or service of lawyer of your choice. Uh, Next, another one is, do you understand your rights? Matlab, the police officer should tell the suspect that if he or she understood their rights and that are explained, the rights include rights to remain silent, right to be represented by a lawyer. The voluntary statements uh, given by any kind are not barred by the Fifth Amendment, and their admissibility is not affected by the Miranda warning. If a suspect voluntarily wants to tell the whole story, so his or her statement is admissible in the court of law. Now, there is a Durham's rule in which it is stated that the criminal defendant cannot be convicted of a crime if the act was a result of a mental disease. If a mentally ill person conducts a conduct a crime, so it would not be he or she would not be convicted for that. Now, the various laws are IPC 1860, that is Indian Penal Code. It defines offences and prescribed punishment. It was given by Lord Macaulay, started in 1836 and completed in 1860. Another one is Criminal Procedure Code CRPC 1973. It defines the mechanism of punishment. In Indian Evidence Act 1872, law of evidences is given. The various sections of IPC includes section 29, which gives the definition of documents, section 44, definition of injury, section 81, act likely to cause harm without criminal intent, section 84, McNaughton's rule, that states that nothing is an offense which is done by a person who at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of act. Immediate restraint of the mentally ill person. Section 92, act done in good faith for benefit of a person without consent. Section 201, disappearance of evidence by a forensic scientist intentionally. Section 228, it deals with printing or publishing the name of victim of rape is punishable. Section 299, culpable homicide not amounting to murder. Section 300, murder. Section 304A, homicide by rash or negligence act. Section 304B, dowry death. Section 307, attempt to murder. Section 320, grievous hurt. Section 326A, voluntarily causing grievous hurt by the use of acid. So it is acid attack cases. Next is Section 327, causing hurt to extort property. Section 331, causing grievous hurt to extort confusion. Section 332, causing hurt to deter public servant from duty. Section 334, causing grievous hurt on being provoked. Section 354B, outrage the modesty of women. Section 375 and 376 are deal with rape. Section 376A involves rape resulting in death or persistent vegetative state. Section 376C, member of armed forces commits rape. Section 376E, punishment of repeat rape offenders. Section 376F, teacher commits rape on student. Section 376N, person commits rape repeatedly on the same women. Section 376G, person commits rape during communal violence. Section 509, insulting the modesty of a woman. Now the various CRPC sections include the section 154 for FIR, First Information Report, section 173 for the submission of charge sheet, section 174 police inquest that is conducted by the sub inspector, section 176 magistrate inquest which is done in cases of death in police custody, by death by police firing, death in prison, reformities, Boston School, psychiatric hospital, or dowry death within 7 years of marriage, exhumation, and rape in police custody or other authorized by the court. Section 23 includes magistrate states that magistrate inquest should be conducted by the district magistrate or the collector, deputy commissioner, subdivisional magistrate, tehsildar, or other executive magistrate. Section 26A, rape cases should preferably be tried by a women judicial officer. Section 61 to 69, subpoena or summons. It is under penalty. It is a document compelling attendance of a witness in a court of law under penalty. So the court gives summons to the witnesses, and they have to appear in the court. Section 91, summons must be obeyed and the witness should produce documents if asked for. Section 157, the crime scene being the richest source of various types of evidences must be searched thoroughly. Crime scene searching. Section 291, deposition of medical witness, out of court oral testimony. Section 292, evidence of officers of the mint. Section 293, reports of certain government scientific experts. Section 366. In section 293, it is mentioned that the reports of the government scientific experts is admissible in the court even if the expert is not present. It can be explained by its assistant or so, and if there is a need, the scientific expert should be summoned. Section 366(1), the death sentence before being executed is required to be confirmed by the High Court. The various sections of Indian Evidence Act are Section 3, in which the definition of documents is given. Documents mean any matter expressed or described upon any substance by means of letters, figures or marks, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. Section 32 is dying declaration, compos mentis. That is, before recording, doctor should certify that the person is conscious and his mental state is normal. Dying declaration is recorded by executive magistrate or else recorded by the village headman, police or any other person, but its evidentiary value is less. The one recorded by the magistrate has the most evidentiary value. In section 45, the definition of expert and the opinion of experts is given. Section 45A, opinion of examiner of electronic evidences. So, section 46, facts hearing upon opinion of experts. Section 47, opinion as to handwriting, whether when relevant. Like, for example, any acquaintance of, for example, my friend or my family who knows my handwriting very well can also give their statement whether the handwriting belongs to me or not. 47A, opinion as to digital signature when relevant. 51, grounds of opinion, on what basis the opinion is formed. Chapter 4, section 59 and 60 deals with oral evidences, and chapter 5, section 61 to 73A deals with documentary evidences, and section 75 is for private documents. Section 105, law presumes that every person is sane and the burden of proving mental illness is on him. As I have already described that the person with mental illness cannot be convicted. So if the person is mentally ill, it is the burden of proof on that particular person to prove that he or she is mentally ill. Section 143, leading questions. Section 159, experts may refer to the books. Thanks for watching. For more such videos, stay tuned to our channel. Thank you.